Good afternoon, and welcome again to the 2024 Part 200 Uniform Requirements Update session. Today, we plan to provide information and guidance around several updates made to the Code of Federal Regulations that impact grant making. Now, in this course, we're going to introduce some of the updates that are made to the 2 CFR Part 200 that impact the Office of Justice Programs, or OJP, at the Department of Justice. My name is Lisa Harpin. I'm part of the training team with the Office of Audit, Assessment, and Management. And the presenters that you'll be hearing today will be Jen Tyson and Trayvon Tillman, and they will introduce themselves when they are ready to get started. Now, we'll start with a brief overview of the revisions that have been made to 2 CFR Part 200, as well as the timing in which these changes will take place. Again, Jen Tyson and Trayvon Tillman will talk more in depth about each of these changes, and will provide implementation guidance and general guidance on each one. At the end, we'll offer you some resources that will help guide you following the session. This session is being recorded, and there will be a recording offered at some point in the future following these sessions. So I'm going to turn the session over to Jennifer Tyson now, and she will start talking to you a little bit more about what we're going to talk about today. So, Jen?
Great. Thanks, Lisa. So I'm Jen Tyson. I am a Deputy Director in Office of Justice Programs, Office of Audit, Assessment, and Management, and specifically over our Grants Management and Policy Division. So I've been with OJP for a little over 15 years. When I started, I was a grant manager in the Office of Juvenile Justice and Delinquency Prevention. As you all were joining, I was trying to scroll the names and see if I recognized anyone that I had worked with. But I have been with OJP for a while. Prior to coming to OJP, I had worked both at a university and at a state agency and was a recipient of DOJ grant funding. So it's great to be here today and talking to you all. I am joined by Trayvon Tillman from our Office of the Chief Financial Officer. He'll give you a little bit of background when he starts, but we're really trying to share this presentation today. I'm going to be covering the parts that are a little bit more sort of grants administration, overall grants processing, and Trayvon's going to dive a little bit deeper on some of the financial aspects of today. I do want to just set some expectations, give a little overview of what we hope to accomplish. So we saw by the poll that I think a lot of you are familiar that as of October 1st, right, OMB issued updated Part 200 uniform requirements. Part of our goal today is to make sure you're all aware of this. I do see in the chat that there is a question about hearing, so I just want to make sure from the other panelists that you can all hear me okay?
Yes, we can hear you, Jen.
Yes.
Okay. All right, I think we'll continue. So part of this is to make sure you're aware of that these updates did take effect on October 1st. We also want to talk to you about how this update affects your OJP award. And the concept that I'll introduce early, and then we'll go into greater in detail shortly, is that for OJP, it's the date of the action under the award and not the date of the award, the date the award was issued, right? So we will go into a little bit what the date of the action means, but that's something that I just want to, seed in your sort of awareness right now, that this might be a little different, right, than other federal agencies. We'll get into why DOJ, OJP might be a little different, but keep in your mind when we're going to dive in here that the timing for OJP has to do with the date of the action you're taking under the award and less so about the date that the award was issued. We do want to dive into some of the substantive changes and the key highlights of how we think those changes could affect your OJP award. I'll let you know up front that we are not going through a line by line of all hundreds of pages of the updated ECFR. We are instead really trying to, highlight. We've done a review of it based on the questions that you've submitted to us in advance. We really tried to structure the content around the questions we were hearing from you all in registering, hearing from the grants management staff internally, and also those aspects of the changes that we think are most likely to come up. That being said, we're going to leave you with some resources at the end that you can certainly follow up on. But this is, really us trying to curate the things that we think could be most likely to come up in the context of your award. The other thing I'll just set expectations about upfront, and again, all of this we're going to go into greater detail, but even though it is applying based on the action you're taking on the award, if you have an existing award, right, that most of the time, often, in order to apply the updated requirements, you will likely do a grant award modification, meaning that all of our guidance around what requires prior approvals is still in place. So even if, there's something that might be more relaxed or lenient or thresholds may be higher, you could potentially benefit from that, right, and propose that under your award and through a grant award modification. However, this is, again, something that I just want to plant the seed up front, because we're going to emphasize this point throughout. We want to make sure you know that likely you would still need prior approval. Likely you would still need to submit that grant award modification. And finally, and I did touch on this a little bit, is that we do want to leave you with some resources. One, DOJ Grants Financial Guide, right? So this is where really we have our financial staff from across OJP, COPS, and OVW, who are our sister grant-making agencies in the Department of Justice here, work to translate to sort of a user-friendly version of, the parts of 2 CFR Part 200, as well as other federal laws and guidance, sort of the full, the summary of the most, the impactful guidance and regulations. And so this is something that we have been working on updating. We expect the updated publication to come soon, but this really is the, where I would say your first sort of source and follow-up. That being said, we will also provide some other resources that we hope you can take away from this session. So that's just a little bit of what we plan to cover today. With that, let's go into the next slide. And first, we'll just start with a step back. And I recognize that probably many of you might know this, but if you're newer to grant making or being a grant recipient, I just want to start with a little bit of background on what is the Part 200 uniform requirements, right? So the Office of Management and Budget, OMB for short, right? They set the federal-wide guidance for federal assistance. Federal assistance means grants and cooperative agreements. It includes, right, the uniform administrative requirements, cost requirements, audit requirements, and all of it, right, it's codified in Part 200 of Title II of the Code of Federal Regulations. What it does in there, right, it's those general sort of provisions, it's that general guidance that is applicable to all our grants and cooperative agreements. It covers, if you haven't looked at it, right, the entire what we call grants life cycle, everything from the pre-award process, which from our perspective, right, is planning for funding opportunities, posting those funding opportunities, receiving those applications, all the way through to sort of how you review them, how you work with recipients, what types of changes require prior approval, and how the closeout process works. So it is, if you're newer, you haven't looked at it yet, it's really that whole grant life cycle. And like I noted, it does include those cost principles as well. But the one thing that you may or may not know is that even though this is federal wide guidance, that each federal agency essentially has to adopt the guidance through their own regulations, right? So Department of Justice adopts this Part 200 through DOJ's regulation, which is 2 CFR Part 2800. There's a minor supplement for one of our grant programs, the Burn JAG program there, but in general, right, that's our regulation. The reason that this matters is that, how this, when Part 200 is updated, how it's updated, and how it applies to awards, because each federal agency adopts it through their own regulation. I do want to just, emphasize the point that how DOJ adopts it, especially as it pertains to timing and its application to current awards, might not apply to other federal agencies because all of us independently federal agencies need to adopt the cross-cutting guidance through our own regulations. Again, and I'm sure you're going to be a little tired of me saying this, but it is a key takeaway we want you to have here, which is the DOJ grants financial guide, right? It's that summary, it's that key information that we really do think is the takeaway. So we're going to summarize today, really some of those changes. But again, going back to that grants financial guide is I think it's just a great resource. Next slide, please. So now that's just a little bit of background, right, on CFR Part 200. But now what we really want to focus on today is what changed. So as hopefully you're aware, we noted at the beginning, OMB updated portions of Title II of the Part 200 really of CFR, including Part 200. It went into effect on October 1st, 2024. So I think the important thing I'll say here is that OMB updated portions, right? So if you remember back, if you've been around for a little while, 2014, right, there was a comprehensive consolidation and update. And that, I think, by comparison, was maybe a little bit more sweeping. There are important and substantive updates in this, version that is effective as of October 1st. However, I think the thing that I'll just keep in mind, part of what we're highlighting here is that not everything changed, right? A lot of things changed in maybe minor ways. There's definitions or small definitional changes, clarifications in terms, but not really changing the substance of the guidance. In other cases, right, some of the substance of the guidance changed, and that's what we want to try and highlight. If you are interested, again, some of these supplemental resources, I would certainly highly encourage you to take a look. The Council on Federal Financial Assistance has essentially a sub-site established around the uniform guidance. This is the URL here. This is also something we link to on OJP's website, where, there are a number of resources there summarizing the changes. I'm also publishing the red line version. So the red line version is the version where you can look in and see what edits were made from the past. So definitely encourage you all to take a look at that. Because again, what we're trying to do today is highlight the key changes, but it's certainly not going through the entire document. Again, DOJ Financial Guide, great supplemental resource here. Next slide. So now we're going to get into a little bit of the meat here in terms of what the applicability of timing for Part 200 means for the OJP, Office of Justice Programs Awards, right? So to start, the implementation date for DOJ in general, right, OMB established it October 1st, 2024. That is the date that the Code of Federal Regulations changed. So OMB, if you were following, OMB made the announcement back in April, but they made the announcement, and then with that, essentially the changes were forthcoming, right? And so that in general, the implementation date was October 1st, 2024. The electronic CFR, the eCFR, all of that was updated on October 1st, 2024. I know I already touched on this, but I do think it's an important point to mention and emphasize here is that because even though OMB, right, set the implementation date, because the agencies have their own adopting regulation, exactly what that means for implementation timing, especially as it pertains to current awards that were, that were open still on October 1st, it may be different. So I just want to caution you that what we're talking about today is really your awards that you have with the Office of Justice Programs. The resources from OMB are something you can look at for other federal agencies, but I don't want you to, assume just the timing that we're providing today would be the same as other federal agencies. And I know for a fact that in some cases it's likely different. So with that context in mind, what we're going to do is walk through just a few scenarios on how the timing of the revisions apply to the different awards based on when they were issued. We're going to start with probably the easiest case, which is awards made in fiscal year 2025. So that fiscal year started October 1st, 2024, right? So that is the start of the implementation. They're issued, right, in 2025. Essentially, that's where it's probably the easiest, right? Like they're issued after the date the revised Part 200 takes effect there. That would include subawards and contracts under those awards. That being said, even if you were, notified of the award after the 25th, if it includes, for example, some proposals in your application, you still might need to go through the grant award modification process to actually apply the changes. Because sometimes, right, you came in, you applied, and the time you applied, it was the previous guidance, right? And now you've been issued the award. If you're modifying something substantive from your application, you still need to go through the grant award modification process. Also, the updated guidance, obviously, and again, it's just a point that we'll emphasize, does not, affect those actions taken prior to October 1st. So that's like maybe the most straightforward example. But again, even with the straightforward example, there's a little bit of nuances, especially in this timing, right? Many of you, if you are receiving 2020 awards, around the end of the fiscal year or even in the upcoming weeks, may have started that application under the previous guidance under the, prior to October 1st. So again, just keep that in mind. Next slide, please. So as it pertains to awards made in FY24 and earlier, so this is where that concept of recipient award actions comes into play, which is that the revised Part 200 uniform requirements applies for recipient award actions on or after October 1st, 2024. We have a slide in a second that gives you some examples of what recipient award actions are, but what I'll start with a little bit with what it's not. It's what an award action isn't per se. It's not necessarily the date that you were issued the award, right? That is the award notification date, that's the award start date, but the recipient award actions are really, it's those things like entering into a subcontract, right? That is an award action that you are taking under an award. And so it's the date in which you are entering into the subcontract within an award that is the award action. It is the date at which you are submitting the grant award modification in order to modify something on your award, and that is going forward prospectively in the future. So it's those types of actions that would apply. So meaning any action that is taken October 1st, 2024, and after, it is the revised uniform requirements that would come into play. But again, you generally need to take that action in order to apply it, meaning it's not that, like, if you wanted to, and we'll get into one of these examples, modify an indirect cost rate, it's not like that automatically happens, right? It's when you're negotiating that indirect cost rate after October 1st, 2024. And the key piece here is that this does not retroactively apply to recipient actions taken prior to October 1st for OJP here, right? Those are still subject to the previous Part 200 uniform requirements. And so meaning that if you were to submit a budget modification today and you're saying, hey, I wanted to apply to things I spent a year ago, the answer is going to be that's not going to be approved, right? Because we are not retroactively applying the new guidance to actions that took place prior to October 1st. So you're submitting the GAM today. If you're saying, hey, this applies a year ago, when we review the GAM, essentially it would not be approved because we're not retroactively applying that, the revised guidance in the past here. If we go to the next slide. So here's just a few more examples of what recipient award actions are. And these are probably the most common ones. It's when you're obligating or incurring project costs. It's when you're making the subawards or entering into those procurement contracts. It's when you're negotiating or renegotiating indirect cost rates. It's when you're doing the budget and award modifications. Again, even though you're submitting it, it's about the period of time in which you're planning on applying those modifications. Those are the actions, right? Those are under a funded award, the types of administrative actions, the types of programmatic actions that would be covered under the revised Part 200 uniform requirements. So again, I know this is a nuance that is and specific to DOJ's regulations, to OJP's implementation here in terms of the award actions. And so I do want to make sure that that is emphasized in this. It's something we're emphasizing throughout, and we'll get into a why in a second here. If we go to the next slide. So it might help if we talk a little bit about why, and I know I've touched on this, but if you take a look at your current award agreement, you'll look at the award conditions, and it'll reference either by, directly or through link DOJ's regulation, which we already talked about, which is Part 2800. And if you go read it, essentially it expressly includes any subsequent changes to Part 200. The standard award conditions about the applicability of the Part 200 uniform requirements applies Part 200 as is adopted and supplemented by DOJ. And then that's related but distinct award condition about compliance with DOJ's financial guide includes any updated version that may be posted during the period of the performance. Right? So the pattern you see there in terms of DOJ's regulations, in terms of DOJ's OJP's award conditions here is that, as it's changed, as it's adopted, as it's supplemented, as the updated version, even though it's in that period of performance, it applies as those revisions are made. So that is why, right? This has to do with our regulatory framework as well as the award conditions that are specifically applied to your existing awards. Again, that does not mean just because it's DOJ or OJP that applies, that the same circumstance applies to all other federal agencies.
So now we're going to talk a little bit about the OJP's approach to these uniform guidance updates. And in this presentation, what we're doing here, because we will provide the slides afterwards, we're indicating on the slide that you see on the top part of the screen with the blue, the wide blue border on the left. This is the actual Part 200 language that we're discussing. So each of the discussion points that Jen and Trey will go through will show you the exact language first. I'm not going to read it to you. We're just including it with slide deck so that you have it at the end. But then you're going to talk a little bit about what that particular, the considerations for implementation of that particular language are going to mean to you. So just keep your eyes open for the 2 CFR official language banner. That, again, is coming from 2 CFR. And then the next slide will generally be an explanation of how that will impact you. So I'll go ahead and turn it over now to Trey. Trayvon?
Hello. Okay, thank you. Brief introduction about myself. My name is Trey Tillman. I've been with the Office of the CFO for about a year now, where I work as a trainer as well as work in policy. My background is audits. So for over 10 years, I've done a number of audits over several different organizations, whether it's state and local governments, nonprofits, higher education. And from there, my specialty was the single audit. So for all of you who have 630s, I'll be knocking at your door right about now. So one of the things that I enjoy is 2 CFR 200. I was one of the 3 that said they read it from top to bottom. So, looking for this and can't wait to get into some of the details. So one of the first things that we wanted to talk about were the definitions. And with those definitions, some of the changes that were implemented was equipment. So the threshold for equipment went up to 5 to 10,000. And for some of these subjects, we're also going to talk in more detail. Like, for example, with equipment, you want to make sure for your CAP policy, your capitalization policy, that you show that your threshold is going to be 10,000. If you're going to use the $10,000 threshold, you should have a policy and a procedure around that. Now, there's a definition of for-profit organizations. And then for the modified total direct cost, which we'll talk about later, the subaward threshold increased from 25 to 50,000. And within the 2 CFR, there were a lot of things that were kind of done to make it almost like simplified. Like, for example, words like non-federal entity were replaced with recipient and subrecipient. Instead of F&A, indirect costs were being used, and also instead of matching, cost sharing was kind of being pushed around. Okay, next slide, please. Next slide. Thank you. So from there, go back. So from there, one of the things that the OMB wanted to make sure that was spelled out within the compliance were whistleblower protections. So there's always been protections for whistleblowers, but now is in the language outline, redline. And one of those things, if you're an employee, a recipient, subrecipient, you cannot be discharged, demoted, discriminated against, reprised against, or anything should you go and whistleblow. So we've seen some instances where whistles have been blown. You know, I'm also a CPA and CFE, and when we investigate fraud, one of the things we look for is the fraud triangle. And within the fraud triangle is basically 3 steps to it. One is the opportunity. The other is, let's see, opportunity. Oh, draw a blank. Justification, opportunity, justification, and then it was another. Well, it's on the tip of my tongue. But with that, if you were to see some of those, we encourage to blow the whistle, to let that be known. So if you see those things, if you see something, please say something. Okay, next slide, please. Now we have an IG. So if you see fraud, waste, or abuse, please reach out to our IG, as well as any grant managers or financial managers that you have on staff. And for more information on the process to do any reporting, please check the financial guide. So as Jen said earlier, we have a ton of resources, and within the financial guide, if you see chapter 3.20, you'll see more information on the hotline. We have those hotlines, as well as those protections for any whistleblowers. So indirect costs. So generally we get a ton of questions around indirect costs and what's the big change. So we want to start here with the MTDC, modified total direct costs. So the definition remains the same. The big change is it's going from 25 to 50,000 for subawards. So generally, when it comes to the MTDC, that's what you use for your de minimis. So when you take the new 15%, it has to be on these. So you have your direct salaries and wages, applicable fringe benefits, materials and supplies, services, travel, and up to the first 50,000 of each subaward. Beforehand, it was 25. Now it went back up to 50. So with this new change, one thing, the GAMS will also come into effect as well. So if you're going to use a new base, then you're going to have to do a new calculation, and a grant modification will have to be done. Excellent. So again, if you continue to use the same indirect costs in an agreement, then you will have to renegotiate. The existing indirect cost rate, again, has to be recalculated if you're using a new base. So if you went from the 25 to the 50, then there's a new calculation that has to be done. And then from there, you'll have to do a budget modification based upon that calculation. Okay. And also going back to the action. So let's say, for example, you wanted to do the calculation based on costs that occurred prior to 10/1, October 1st, that wouldn't be allowed. The action has to take place October 1st and thereafter. Next slide, please. So back to de minimis. So with the de minimis, look at the de minimis. Basically, if you don't have a negotiated cost rate, then you're able to use this particular rate up to 15% of the MTDC. Okay, so that's the big thing when it comes to de minimis. If you don't have a negotiated cost rate from a cognizant agency, whether it's DOJ, HSS, or whomever, you can charge up to 15% of the modified total direct cost based on the definition that we just said earlier. And then in addition to you being able to use 15%, in the old days it was 25,000. Now you can also use up to 50,000 of the subawards within that MTDC. Slide, please. So again, some of the things to keep in mind: negotiated indirect cost rates will remain the same until renegotiated. So if you have a negotiated cost rate that, let's say, is 12%, then you wouldn't be able to take the de minimis until you renegotiate. Okay. Now, sometimes, generally, you can go lower, but you won't be able to go higher. Okay. So you'll be able also to submit budget modifications prior to October 1st. So if you already got it in, that's fine. But again, the action would have to take place on October 1st and after. Okay. And again, it's up to 15%. So you can go below the 15% threshold as well. Now, federal agencies may allow you to apply the 15% de minimis on existing awards, but please keep in mind that there have to be enough funds for this. So although you may be able to get the 15%, if there aren't funds available, then there wouldn't be anything to give. And once again, budget modifications. So although it is allowable, please submit your GAMs, get those in as soon as possible to be able to get the awards and what you want and what you need for the new de minimis rate. Okay. Next slide, please. So equipment. So these are some of the new equipment rules that kind of came down the chain. So beforehand, only states were pretty much able to use their own processes and procedures when it came to how they manage, dispose, and used equipment. But now, if you're a tribal organization, beginning on October 1st, you're also allowed to use your own policies and procedures when it comes to, again, using, managing, and disposing of equipment. Right. So, hey, this allows more tribes to, when they have, in sovereign nations, when they have their own policies, when they have their own procedures on how they do things, you're allowed to use it now. But again, the action has to take place on October 1st. So let's say it's September 27th, then that tribe, you wouldn't be able to use your own policies. You would have to go back to the old rules. But starting on that 10-1, then you'll be able to do so. And it's the same way with procurement. So again, in the past, states only could use their own policies and procedures when it came to procurement. Now, Indian tribes have that ability as well. You just have to still follow rules 321 to 323. So 321 to 323, that just kind of deals with women-owned businesses, minority-owned businesses, veteran-owned businesses, as well as procuring goods in this country, making sure that certain conditions are in the contract. So those things are still there, but outside of that, you can use your own policies and procedures. Okay, and a lot of the thresholds are the same too. So simple acquisition is still 250,000, and the micro purchase 50,000 and things like that. Good. So again, the revision, it allows the tribes to dispose, manage, and use equipment in accordance with tribal law. And it also allows the tribes to pretty much be treated as states. So you have the same, I don't want to say leeway, but you have the same space that a United States would be able to have when it comes to some of these things. Just keep in mind that your subs would have to follow, subrecipients would have to follow 2 CFR 200 to a T. So although you have that ability, your subrecipients and any recipients of those subs will still have to follow 2 CFR 200. And again, back to the action. So let's say after you went into a contract on September 27th again, then you would have to follow the old rules. But if you got into that contract on October 2nd, then you could follow the new rules. All right. And just the only outliers are like 321 to 323 and 327. So with that, those are just making sure goods are procured in the United States, giving more to women-owned businesses, minority, veteran-owned companies, and making sure certain conditions are in your contracts. Slide, please. So another thing to keep in mind is competition. So one of the things with the new GS2 CFR is that it allowed, when it comes to procurement, you're now allowed to not worry about a geographic preference. So in the past, you couldn't say, hey, I only want to do procurement for people that are within my range and were relocated in the DMV. Now you're allowed to have things like that. Okay. And then also what was added is veteran-owned businesses. So now you get more when it's almost like you get more leeway when you use these type of firms, these type of businesses. Those are the ones that should almost like get the highest bid. So when it comes to your bidders list, you're allowed to push companies with those type of accolades to the top. Okay. So that's another good thing to keep in mind. So from there, this is something to consider when preparing new contracts. And in addition, you're also allowed to have like a scoring system. So let's say you're in a situation where you could say, hey, I'm going to set up a score, and these companies that are going to implement a certain amount of jobs or a certain amount of benefits or a certain amount of trainings, we're going to push them towards the top where they get the highest score or something like that when it comes to your bids. That's allowable too. So just some things to keep in mind, as well as for your auditors and your monitors. So now that's allowable. So if they try to say, hey, what's going on here, you can come back and show CFR 200 allows this. Okay. Next slide, please. So again, back to more some of the definitions that we talked about earlier with equipment. So the definition is pretty much 100% the same. It's just the amount. So generally in the past, if it was 5,000 and below, you had to expense it. Now we're opening up that threshold up to 10,000. So anything $10,000 and below, you're allowed to expense, and above 10,000, from $10,001, you can capitalize. You just have to make sure that is one of your policies and procedures. So you should have a capitalization policy that shows this and expresses this. So we should be able to see it in your financial statements as well as in your own policy. Oh. So again, you may need to push out a gap for something like this. If you already had certain things within, now it's going into the equipment category because or let's say you were only capitalizing things from 7,500 and below. Now you got more space with that. So you may have to push out a gap forward. And we also revised the DOJ guide to reflect such. And once again, make sure this is part of your policies and your procedures.
The next part here that we want to highlight is around the internal controls and cybersecurity. So right here is just an excerpt of the language about taking those measures to safeguard information, including protected personally identifiable information, right? So this is something that is being emphasized for federal agency and pass-through entities. And if we go to the next slide, that I do think that what this reflects, and we just want to make sure you're all aware, especially as you're passed through it, entities, that it's really an emphasis, right, on the protection of personally identifiable information. So if you've worked with the federal government or in the federal government, this is something that you're probably familiar with, and probably many state and locals are as well. But this is, it's those characteristics, those, emails and phone numbers and addresses that are birth dates and social security numbers that are unique to an individual. That's personally identifiable information. And so while, there's been a lot of regulations around this for a while, what I do think we want to emphasize here is that it's, really being highlighted that it is the responsibility of recipients to protect that information as well. And part of what OJP monitors for, right, is assessing the entity's use of proper internal controls. So this is something, again, it may be something that you're familiar with, but there's just this added emphasis on really that cybersecurity and that protection of individually identifiable information. I do think the other thing that this also translates to is like you should think about that when you submit information through any grant system. If it's information that is necessary to for the award, then you would need to include it. But a lot of times that can be de-identified or aggregate information, and so keep that in mind. Next slide, please. Now this is one that we probably got a lot of questions on up front. Yeah, probably. I know we got a lot of questions on up front. I'm going to read you two excerpts, and then I'm going to summarize OJP's guidance here. So please keep this in mind. But this has to do with no-cost extensions in particular. So first of all, in the revision, right, a no-cost extension, and it defines this, right, this is the extension time that doesn't require the obligation or additional federal funding. It does say that other than any one-time extension, right, all requests for no-cost extensions to be submitted at least 10 calendar days before the conclusion of the period of performance, and it gives federal agencies the possibility of approving multiple no-cost extensions. So this is language excerpt number 1. If we go to the next slide. One-time extensions, right, in the revision, it also makes a distinction here of what a one-time extension is. And it does say that, right, it is possible to initiate a one-time extension of up to 12 months. And if the conditions specifically say this, right, the conditions of the award, that prior approval is not required, that is possible here. But that's a big if, right? Because what this is saying is this is allowable if the award conditions allow it. And then it still says you have to still do the notification and justification in writing. So what I will say, moving to the next slide, is that for OJP, right, for all extensions, project period extensions, one-time or additional, a GAM, a project period GAM, is still going to be required. The GAM, right, is the procedure, the grant award modification for the project period extension. That is administratively necessary. What happens when you submit those and it gets approved? It serves as both the notification, right, which you saw was in that guidance there, which is notifications are still required, right? The GAM is the procedure in which you notify us. It is also the technical and administrative steps that ensures that all of your award documentation is updated, that the financial systems are updated so you can still draw down the funds. So the GAM becomes administrative necessary in order to both notify and, once approved, to ensure that you have the continued access to funds and all of the records are updated. So the one key piece here, this is, again, the questions that have come in advance, that a lot of them have centered on this, which is, would you still need to submit a grant award modification for a project period extension if it's the first one and for 12 months? And the answer is yes. The recipients, right, you all are also required to submit that 30 days in advance. I know the uniform guidance says 10 days, but the reason that it is 30 days is also about the fact that most of this happens at the end of the fiscal year, right? It's extremely important that a 30-day submission window has to do with how those funds are accounted for, how they're extended to make sure that they, extend into the rollover of the new fiscal year. That being said, right, consistent with the guidance, it is still possible for grant managers to initiate on your behalf within the 30 days, right? So from a system standpoint, it is enforced in just grants. I think from most of a planning standpoint, from a budgeting standpoint, the policy is still that you should be initiating these 30 days in advance. That being said, there are circumstances where it might not be the 30 days. It is still possible. Work with your grant manager to initiate it on your behalf. But this is a point where I would just encourage you. The 30 days is a good planning tool, and the GAM is still required. What I will say too is, right, generally that one-time extension, the first extension of a period of performance of up to 12 months will be considered with supporting justification. The one point here, though, right, is that justification, and this was explicitly in it's in the revised Part 200, but it was also in the previous Part 200, which is the justification cannot be the sole purpose of using unobligated funds, meaning generally you would need to make a supporting justification about the necessity of doing the extension to deliver the goals of objectives and sort of what circumstances led to needing the extension. It can't simply be that we have a balance of funds that we want to expend, right? That's explicitly stated in 2 CFR Part 200, as well as in the justifications that our staff review. Additional extensions may be considered with sufficient justification. So again, consistent with the guidance here, while it may be additional justification, right? Because it's outside of that sort of more routine one-time 12-month extension. But this is where, additional extensions can be considered, especially for certain circumstances, often extenuating circumstances. But that is where we would likely ask for additional justification. So I know I've probably spent more time on this slide, but I do think, just if I can give you that takeaway again, this is project period in particular. Still submit the GAM, still submit it 30 days. If it's less than 30 days, work with your grant manager. Next slide. This is another area that we've got a few questions on about subaward activities. And that essentially that subaward activity is not proposed in the application and approved in the federal award. If it says, right, and this again is the excerpt, that a change in subrecipient only requires prior approval if the federal agency or pass-through entity includes the requirements in the terms and conditions of the federal award. In general, the federal agency should not, or pass-through entity should not require the prior approval or change of the subrecipient unless the inclusion was a determining factor in the merit review or eligibility process. So just to emphasize this a little bit before we go to the next slide, which is that's an important unless, right? Unless there was a determining factor for the eligibility or merit review. So what I'll keep in mind here is that under competitive awards in general, which most significant portion of OJP awards are awarded competitively, right? You come in, there's an applicant pool, it goes to merit review, that's competitive. Those and certain formula funding that changes to subrecipients or subrecipient activities would still need a GAM if it was considered in the eligibility and merit review. So this is a circumstance where, again, if it's competitive, there is a good chance you just have to submit a budget modification or change of scope GAM here to change the subrecipients. If it's formula, that's where we would say work with your recipients. I think that's also those cases where the budget is different, right? It is program to program exactly what the requirements are for formula funding. But I think this is something to keep in mind, that if you are changing, right, who is delivering the goals and objectives of a program, of a funded activity here, I think the first question should be like, do I submit a GAM? If it's competitive, the answer is most likely yes. If it's formula, good chance, but you should work with your, or at least a chance, you should work with your grant manager there. So here's about, and this is where, in general, I would say there's a little bit of a pattern on some clarifications around pass-through entities, which I know many of our award recipients are. And here's another changed clarification around the pass-through entity, which is it does add that the pass-through entity must verify that the subrecipient is not excluded or disqualified, right? And including confirming SAM.gov that the potential subrecipient is not suspended, debarred, or otherwise excluded. Ensure that the subaward is clearly identified to the subrecipient and includes the information below. And there's a whole bunch there. We didn't copy this all, but it essentially is saying, like, structure your subaward here with this information here. And that each, you have to evaluate the subrecipient's risk, fraud risk, and risk of noncompliance with the subaward to determine the appropriate monitoring, right? If we go to the next slide, there's also, right, again, additional pieces here around certifications for pass-through entities and subrecipients about certification about the information being true and accurate. There's a direct quote here about what they need to certify for. And I will summarize this if we go to the next slide. But I think overall, the takeaway here, and I know we took excerpts, but if you go into that whole section, you can see a lot more. What this really does, right, is emphasize that risk assessment responsibility for those pass-through entities. This is something that you may be familiar, and I know a number of pass-through entities probably have been working towards this for years. And at the federal agency, these are requirements that have been imposed on us for a while. But it really is emphasizing that risk assessment. This pass-through entity essentially has to do the same types of risk assessment, fraud-based, or risk of fraud-based monitoring plans, the certifications. That is all, right, really emphasized for the pass-through entity in the revision here. And, something that is good to be familiar with is that OJP monitoring activities does actively examine these things, whether the prime recipient has those written procedures for managing a subrecipient and the award process and ensuring that they're meeting those requirements we just did, right? And that does include checking for the suspension and debarment, containing the award agreement and containing all those elements, that the pass-through entity is conducting those risk assessments, including that risk of fraud, using that risk to inform the monitoring plan, and then documenting the monitoring results, including the single audit. So again, if you are a pass-through entity, this is really emphasizing those responsibilities around risk, and it's something that OJP also monitors for. Next slide. Something that changed here is about the termination of standard closeout costs. The termination and standard costs in closeout. And so what I'll say is, what this highlights, right, is that administrative costs associated with closeout activities of a federal award are allowable. It says that the recipient or subrecipient may charge the federal award during the closeout for those necessary administrative costs of that federal award. And it gives these examples: salaries of personnel preparing final reports, publication and printing costs associated with the disposition of equipment and property, and related indirect costs. And then this is an important part too, right? These costs may be incurred until the due date of the final report. If incurred, these costs must be liquidated prior to the due dates of those final reports and charge the final budget period of the award unless otherwise specified. So that, right, that change of allowing those administrative costs during the closeout is in this update. If we go to the next slide, this change is important. It makes allowable those administrative costs associated with closeout activities that can be charged during the closeout period. The point here, though, is that they must be incurred. They can be incurred up until that final reporting due date, but they must be liquidated by the due date as well, right? So they can be incurred. They have to be incurred and liquidated no later than the due date of the final report. Final reports for OJP awards are due 120 days after the final project period end date in general. So unless there's an exception to this, which would be program specific, that is the most general, meaning that during that closeout period, right after the project period ends, it is allowable to charge those administrative costs as long as they're incurred before the final report and liquidated before that final report. One of the updates that are coming in the DOJ financial guide is around the period of availability of funds, so that's definitely a good resource to reference there. And this is probably just a good point in general, but this is where you would just take care to document the costs and be prepared to provide those costs during audit reviews and in-depth monitoring, right? So this allows for those administrative costs and allows you to charge them throughout the closeout period. But it is where it's just important to keep that documentation of those costs. Next slide, please. One of the other changes here is subpart F, the audit requirements. So if you remember, the previous threshold for expending funds during the fiscal year was $750,000. It is now $1 million. So the threshold increased about the same audit requirements. If you go to the next slide, It applies for the fiscal years beginning on or after 10/1/24, right? So it's when the fiscal year starts for the recipient on or after 10/1/24. And this is, what it's saying is, right, if the entity is expending more than $1 million in the fiscal entity's fiscal year, they must have a single audit conducted, except when it elects to have a program-specific audit conducted in accordance to the other paragraph there. In the revision 2, the cognizant agency has the sole responsibility to grant extension requests. So this concept of cognizant agency, you're probably familiar with indirect costs, right? Generally, the agency that you receive the most federal funding from. Similar concept where you would seek and grant extension requests would go through the cognizant agency as well. Next slide. One of the updates that also occurred here is the Appendix 1 for the Notice of Funding Opportunities, right? So there is a lot. Appendix 1 is fairly lengthy, so we don't have everything captured here, but one of the pieces I'll emphasize is that in updated Part 200 here, that potential applicants, the goal here for why they issue Appendix 1 is so that potential applicants can find similar information across all of our federal NOFOs. So all of us as federal agencies really look to this Appendix 1 for those consistent headings, for the consistent placement of the information in the NOFOs to really try to the best of our ability to make that so you find the similar information in similar sections. You may also be familiar that OMB issued a simultaneous memo about reducing the burden and administration of federal financial assistance, which includes simplifying NOFOs. And really their goal there is to increase the accessibility, readability, clarity, and design of NOFOs. So with that sort of context in mind, if we go to the next slide, I'll give you a little preview of what you will expect to see in FY25 from OJP here. First of all, if you've been a recipient with us for a while, you're probably familiar with the fact that we've used the word solicitation for a long time. To align with the updated Appendix 1 and the common use of terminology across federal government, we are going to move to the Notice of Funding Opportunity language. So one, you will see that term more and more from OJP, DOJ, than you have in the past. Second, OJP, and this is where we are working closely with our partners in COPS and OVW, we are undertaking a two-part strategy to streamline our application process and simplify our notices of funding opportunity. It's a two-part strategy, right? So part one here is we have universally applied a set of strategies that's going to reduce, improve, and streamline some of those application processes and improve the readability, accessibility, and simplicity of those NOFOs. Meaning when we start to issue the FY25 NOFOs across the board, I hope you notice that they look different. That being said, right, this is more of what I describe as a surgery versus a sort of, hatchet or, update. And so there still will be pieces in there that, you might look at and be like, oh, well, is this necessary? Could this be clarified? And so what we are doing along with other federal agencies is really piloting with 11 of our NOFOs additional alternatives in submission, language, and guidance. And so, again, just to summarize here with this update, what we expect you to see in FY25 is really across the board. There's going to be some changes to our application process, what we have in those NOFOs, how they look. But then for 11 of them, which will be indicated in the cover page there, we're going to even do this simplification in a pilot way a little bit more. We are developing a really robust measurement strategy to inform where this could go in the future. This is something we are also working across federal government and other federal agencies on and implementing. But please stay tuned. So here are these maybe 6 points that I hope to leave you with. One, they took effect, right? The revised Part 200 uniform requirements took effect on October 1st, 2024. In general, right, and I will say there's a little bit of sort of editorial interpretation here, but in general, right, the revisions are often relaxing and not imposing additional restrictions, meaning the thresholds are higher, they're giving you, the recipients more leniency in terms of you're using internal procurement, policies for tribes. So in general, right, like I wouldn't say everything necessarily, but in general. And so I think that's, hopefully beneficial, right? We think it's a beneficial change. But I think the thing to keep in mind, because, right, you might be interested in applying this, it is that date of the action under the award, not the date of award, which is the determining factor for OJP about which Part 200 applies. So just keep that in mind, meaning like it's that date you're entering into the subrecipient agreement. It's the date you are negotiating your indirect cost rate. It's not going back in time. Prior approval GAMs, outreach to grant managers, often required to apply. I know, I'm sure you all wish that the answers to this were easier, but at the end of the day, right, it's the guidance, but it also, right, is you are receiving awards from specific funding sources with specific requirements. So you really need to look at your award documents. And if you have any questions about that award document, talk to your grant manager. We just want to leave you with the point that, like, you should ask the question, do I need to do a GAM? Do I need prior approval? It's always a good question to ask. Assume the answer is yes, and then if your grant manager tells you no, great. And please keep in mind that this is OJP. We may vary from other federal agencies. This is our procedures. And I will emphasize the takeaway point that if you do have any specific questions about the applicability to your award, please contact your DOJ grant manager. The last point here is that here's just some quick resources. I know we had a few questions about when we're going to post the slides. We do plan to post these, but after we do the next session on October 15th. In the meantime, if you go to ojp.gov, funding Part 200, there's a lot of resources. There's resources here. I encourage you to take a look at these. If you just Google some of these sites too as well, they'll take you there. So I think with that, I am going to say thank you very much for your time.